Thank you everyone for coming. The session is entitled Enforcing the EU's Digital Laws, Delivering European Tech Policies that Serve People, Democracy and the Planet. And it's going to deal with the enforcement actions that are going on at the moment. My name is Penfrat. I'm Senior Policy Advisor at European Digital Rights here in Brussels. And I have the pleasure to be joined by a fantastic panel consisting of Claire Gayrel, Legal Officer for the Digital Markets Act at the European Commission, Viergever, Director of Partnerships and Public Affairs at Murena, Chantal, Joris, Senior Legal Officer at Article 19, and last but not least, Rachel Griffin, PhD candidate in law at Sciences Po in Paris. Thank you very much for joining this panel. I think it's going to be an exciting discussion. Just give it another minute for people to sit down, for people to sit down. Awesome. I'm going to be the moderator, and if I may, will jump in right with one very big question that I will ask to almost all of you. And Rachel, maybe I can start with you. Two major tech laws, the DSA and the DMA, have come into force at the beginning of this year, and the EU Commission takes a central role in their enforcement. In your opinion, when you observe how this has been going, how has the Commission been faring so far?
Yeah, well, they've certainly been very active. So for anyone who's not really been following this closely, they've actually opened 5 sets of enforcement proceedings already. And there have been over 20 requests for information for platforms about possible infringements or things that they're kind of signaling that they maybe want to investigate further. So I think this definitely shows that the Commission is planning to take a very proactive, a very interventionist role in enforcing particularly some of the obligations that are around sort of risk assessment and mitigation that are sort of the broadest, kind of most all-encompassing aspects of the DSA and touch on a lot of different subjects. So kind of priority areas that we've seen multiple actions or requests for information so far include things like child safety, political disinformation, especially relating to the elections, also hate speech and alleged terrorist content, generally things that are in the news a lot, things that are matters of high public concern. I think the Commission is really trying to show itself to be responsive to these public concerns. I think it's also clear that, especially in the way that it's addressing the risk assessment framework, these proceedings and investigations so far are very much not just about sort of compliance with the letter of the law and whether the platform companies are doing the bare minimum, but I think the Commission is really trying to set out its own vision of how these kinds of risks should be understood and mitigated. I think this is actually interesting. So some academics, including myself very much, actually raised a lot of concerns in the last couple of years that because these risk mitigation obligations are so broadly worded and so flexible, that it would basically end up just giving a lot of freedom to platform companies to interpret them however they want. And actually, I think some of the enforcement actions so far are suggesting that maybe that's not going to be so much the case, that the Commission is actually very much going to try and push forward its own understanding of risks. This obviously has some advantages. Obviously, we don't just want the companies interpreting the DSA in whatever way is most convenient for them from a business perspective. But I also think we need to be attentive to some of the dangers they pose. So obviously, the Commission is an executive agency. It is not politically independent, and it is now wielding a lot of discretionary power over questions, if you think about the topics that I just mentioned. So minor safety, for example, a lot of that is around kind of access to content that relates to sex. It's often been tied to concerns around LGBT rights and trans rights, particularly terrorist content and content related to, for example, the ongoing war in Gaza. We have now the Commission wielding a lot of power to push companies to regulate this kind of content in a certain way. And I think that we should be very attentive to the risk that might pose. But I'll let the others add their thoughts now, I guess.
Thank you so much. Chantal, I hand it over to you. How has the Commission been faring?
Thank you, and thank you everyone who's joining us today. So I think also to make a bit of a broader comment, take a step back, I do think it remains still to be seen. I would also focus on the DSA, by the way. I think we have 2 speakers who will focus a bit more on the DMA. So I think it remains still to be seen whether the DSA will be a tool that will be helpful for fundamental rights online or become, from our perspective as a freedom of expression organization, a censorship tool. So I think it's early days to see how it's going, but we are in a context where we see concerning measures from, for example, EU member states that are not necessarily, don't have the reputation as being the most authoritarian amongst them. We've seen France just banning TikTok in New Caledonia in a very extreme measure under the state of emergency laws. We also see a general crackdown on freedom of expression with the context in Israel-Palestine, also the elections coming up. So I think that's like a context that cannot be fully, from which DSA and DMA enforcement can't be fully isolated. Again, it's early days, I think, to see how the Commission has been doing. There's definitely been, I agree with Rachel, very active. They clearly want to show that the DSA matters and will make a difference. But I also think this is exactly why we now need to monitor very closely what they are doing, hold them accountable, make sure that they stick to the letter of the law, and that they do not go overbroad in enforcing the DSA in a way that is more politicized. And we've had early signs that were a bit concerning. Breton's comments about internet shutdowns and platform blocking in times of unrest, or again the letters that he sent to the different platforms after the 7 October attacks, which all indicated that, you know, they might be just rushing things a bit and trying to make a point. Again, now the Commission has taken more actual enforcement actions against many different platforms in many different areas. And I still think, you know, remains to be seen. We've seen, it's a bit of a mixed bag. Some were a bit more positive, I think, against like Meta about demotion of political content, or like the phasing out of CrowdTangle. Other actions against like TikTok Lite, I think, are a bit more questionable. We can go into more detail. But I think for me it's a bit of a mixed bag and sort of remains to be seen still.
And civil society has been pretty vocal, right, as a response to those very early actions from the Commissioner, right, when it comes to the enforcement. Yes,
I think for us it was, again, very important that we do not rush enforcement, that it's not politicized enforcement, that it does stick to what the DSA says, that it does uphold fundamental rights as the DSA at least promises to do. We don't think the DSA is the perfect instrument, but there are some protections that are embedded in there that it's very important that those are really upheld and followed to keep also the legitimacy of the process.
Thank you. Rick, let me turn to you. You run a company that is, well, probably in direct competition with some of the big gatekeepers that are regulated under the DMA, so turning a little bit away from the DSA and towards the DMA. From your perspective, how do you think things have been going so far?
Yeah, it's been interesting times. So some background, I don't run, but I help run a company in this space, it's correct. We are called Murena. Like the fish, and we make smartphones and an online workspace. The smartphones are based on the Android open source project, so the software is a competitor to Google Android, and the workspace is a competitor to Google's workspace online and similar to, for example, Proton. We're very privacy focused. We're 100% open source. And in the past years, we've also taken sustainability more and more on board. And for us, the DMA has been incredibly helpful because in the space where we're operating, big tech companies have so much power that it's actually incredibly complicated and difficult to enter the market. So, for example, when you're talking about Android, which started, I mean, this is not was not started by Google. Google bought Android. And when they bought it, it was an open source project. And what they've basically done is put so many proprietary components in there that now it's virtually a closed system, not as closed as Apple's system, but quite closed. And so many parties are now trying to work together to break that open again for the benefit of both users and businesses and governments, basically everyone except the big tech companies. And it's really nice that we're now being helped by that, in that goal by the European Commission and by the DMA. So I think a really positive aspect of the DMA for us is the fact that it's there and that this is happening, and it sets quite ambitious goals, which is a really positive aspect of it also for us. And I think the process that the European Commission has engaged in the past 2 years has been incredibly positive, at least from our perspective. It's been, I don't know how much you've seen about this on the social media and in their communications, but they've been really open and really inviting feedback and comments. So we've been invited multiple times to give our thoughts, and we're quite a small company, about what we think the European Commission should do to make Google compliant with their regulations. And that for us has been quite nice to be able to provide input in that. And I think it's also smart from the Commission because there's so much technical knowledge involved that it's very difficult for them to get that, to make the appropriate compliance decisions without getting the technical knowledge from the field. So that's the plus side. I think there's also things that for us are less good in terms of how things are going now. Mainly is so in the past half year, the compliance proposals have come out from the big tech companies, how they're going to make their companies DMA compliant. And they've been actually incredibly disappointing. And it's very clear that, and to be honest, this is how I would play it too if I was them. They've very clearly, are trying to get away with the absolute minimum, and in some cases even less, just nothing. And I think they're just trying to see how much the European Commission and partners in Europe are paying attention and how much they can get away with. And so the compliance proposals are really quite disappointing. And there's a lot of work to be done, I think, for the European Commission, but also for us in terms of helping the Commission with that to get those compliance agreements to a standard where it's actually beneficial for European citizens, but also small businesses and governments, because a big topic here is also European digital sovereignty. So there's a huge incentive for European governments at any level to move away from the monopolies that big tech has. And finally, I think, not a negative side, but because it's understandable, because you have to go in steps, but sometimes we have the feeling that even though the goals are quite ambitious already, and we've been positively surprised, we also think that more can be done, and sort of like the point on the horizon could be set higher. And I'll give some examples for that. So, for example, in terms of interoperability, we've seen that there's now, there will be interoperability between messengers. This is fantastic, so you can be on Signal, you can be on Telegram, and you can be on Matrix, and next year we can all talk to each other, which is fantastic and should have been done much earlier. But this interoperability, for example, hasn't been mandated in the area of social media, where it could equally be mandated. Another example for us in the DMA, which is really relevant, a very good point of action is app stores. So there's a lot of media around the DMA and the European Commission requiring both Apple and Google to allow what they call side loading of applications. That's really a stupid term, we think. It means just installing applications from the internet, just like you do on your PC. Side loading makes it sound negative and like it's something weird, and I think it's a coin that was thought up by Apple and Google to keep it away and keep the focus on their app stores. But there's a lot of things happening in this area, and we will see more freedom in this area in the next few years. Sorry, but where we don't see this, for example, is in terms of freedom of operating systems. So for smartphones, it's quite a lot harder currently to install alternative operating systems than for PCs. So you can grab almost any laptop here in the room and install Linux on it, even on some of the Apple laptops, but certainly most of the laptops that normally come with Windows. But with smartphones, this is quite different, and this certainly doesn't have to be different. Like, companies could be mandated to change this. But the European Commission is not doing very much in this area, and we believe that they should. The goal on the horizon should be that any piece of hardware should be able to run any operating system, or at least operating systems should be, it should be open to operating systems being designed for it. And then within operating systems, there should be freedom for applications, for app stores, for payments. So it's a broader vision, and sometimes there's too much focus on something that's really tangible, because I think it's an easy win for the Commission, and I understand that because they need that also at this stage politically. But we also think that sometimes the bar can be set a little bit higher for a complete and fully open ecosystem. Sorry, that was a bit long, I think.
No, that's very good, thank you. Claire, I turn to you. You've heard a good amount of praise and also some criticism, partly about how the laws have been enforced so far, partly about the things that might not be in the laws yet, but should maybe be added the next turnaround. What is your view on your perspective on that? What are the biggest challenges? What were the stumbling blocks for the enforcement teams when you started to get this going?
Thank you, Jan, and thank you for, the feedback communicated regarding the work of the Commission. Alors, I'm working mainly on DMA, but I work in DG Connect, and next door there is also the DSA colleagues working hard on the enforcement of the DSA, so I try to give a bit of view, although, of course, I'm more, of course, aware of what we are doing under the DMA, at least. So there's been quite a lot of challenges so far. I think you all mentioned, that these laws set quite ambitious, goals. They also set ambitious timeline. And I think that we've been working hard in order to deliver within, at pace, the designation of the very large online platforms, as well as the designation of gatekeepers within the strict timeline set by the legislator. All this has been quite challenging and has happened very well. We are also gaining experience. So the recent designation of booking has been maybe even more and easy, let's say, to handle, because we are even more familiar with our text now and how to, work with it. So things are also getting more mature on our side and how we work with these pieces of legislation. The regulatory dialogue post-designation has been very, very intense, with all 6 gatekeepers designated at that time, 22 core platform services subject to many obligations in the DMA. I didn't make the calculation, but we have a lot of open work stream, and for each of them, we have engaged individually with each gatekeeper for each core platform service on compliance with each obligation of the DMA. I hope you will appreciate it represents a very, very significant work. We, of course, in the course of this regulatory dialogue, we could observe the progresses and some achievements which have been obtained in the course of this dialogue, but we have also, of course, observed the resistance in certain areas or divergence where we could not converge with the gatekeepers on a common understanding of what the law requires them to do. So in these cases, we have assessed how to do, and there are a number of ways. So, of course, investigation, you must be aware, we opened a number of investigations. How did we make, a bit our, choice there? What I can say is that the Commission is guided by the principle of good administration and proportionality in how we are going to handle all this, our enforcement task. And in doing that, the more we gained understanding of what is going on and how gatekeepers are doing in relation to one obligation or the other, we were able to better understand where certain practices are likely or more likely to severely defeat the objective of the DMA. And so sometimes to be effective, you need to be selective. And it's true that we need to set up a number of priorities. And we have chosen in the open cases which, let's say, cases we considered as our initial, let's say, priorities for now. Does it mean that we are only interested in self-referencing and Alphabet, Meta's Consent or Pay, or App Stores and Apple? No, because the regulatory dialogue continues with the gatekeepers on all the other areas where we believe that full compliance is not there. And so this is in parallel. It's just that we are pursuing the objective of the DMA through another way than opening investigation, because there is also potential indication that we might achieve closer compliance or greater compliance in the next month by strengthening our regulatory dialogue with the gatekeepers on some areas. So let's see. And in a way, we somehow progresses like that, and we will see, and the Commission is committed to I believe, ensure the greatest compliance with the DMA as rapidly as possible. So if it means opening new cases, this is absolutely not excluded. The Commission is also thinking on other ways to bring closer and greater compliance, which could also be in maybe issuing guidance or guidelines, because we have this ability under Article 47 of the DMA. If I don't say a mistake, maybe it's not 47. But we have, let's say, this competence. So it's also, you know, trying to make the best of the avenues in this instrument and trying to use the right mechanism and the right tool for the right problem. So that's a little bit the exercise we are doing. So I'm happy to hear that certain things have progressed, because this is also what we think. We still think that the DMA has already delivered on a number of achievements, but we are fully aware of the compliance gaps and the need for extra work, and this was expected. Let's be clear.
Thank you so much. Just a matter of interest, and I guess for people in the room as well, can you say how many people are working on the enforcement of the DSA and the DMA at the moment?
I can say for the DMA, I think we are about 80 and spread between DG Comp and DG Connect, because this is a core responsibility of these two DGs. So we are working fully together, the two DGs on the DMA. DSA is entirely the task of the Connect, with the support of the Joint Research Center, as you must know. But on this, I don't know. I don't have the figures, but a lot. Quite a lot. And many more hiring.
How many gatekeeper lawyers are you dealing with?
Oh, much more than us. But we have the law with us.
Okay, let's maybe jump back to the DSA for a brief moment. So we've heard that there have been a number of investigations and requests for information, which is the first step of an investigation, basically, or leading to investigation regarding very large online platforms under the DSA, but I guess also under the DMA for gatekeepers into non-compliance. And so I'd love to ask Chantal, you and Rachel, maybe like how complete are these in your view so far? What is missing? If you could choose one thing that you say, this must be investigated ASAP, what would it be?
Yeah, so as Rachel mentioned, there have been investigations opened and requests for information covering quite a broad range of topics. Again, because our main source of information are basically the press releases, it's also a little bit hard to know exactly what is investigated and at what depth, beyond just like, okay, they're looking into XYZ issue that is described in like one paragraph, right?
We can't hear you with that. You need to talk.
Oh, apologies. Is this better?
Yes.
Okay. So as I was saying, it's a little bit hard also, I find, from the press releases. You understand what topics they are investigating, but exactly what they're looking into, at what depths, or exactly what issue they identified is also not fully clear to me, just based on the press releases. And one thing that I want to say as well is that we might not only be concerned about investigations missing, but again, we're also not in favor of all investigations that have been launched or measures that have been taken. TikTok Lite, the effective suspension, being one example where, to me, it wasn't exactly clear, was this as an interim measure, how the DSA doesn't really talk about suspension of services as an interim measure. Was it for, again, some sort of repeated non-compliance? Where does this come from? So again, we need a bit more transparency. What I haven't seen yet is some investigation that really addresses, for example, something that we always point out is over-removal of protected speech, for example, on online platforms. Again, maybe to take the example of what has been happening on online platforms following 7th October attacks, there has been a lot of documentation of over-removal of pro-Palestinian content, for example. Human Rights Watch, amongst others, but Human Rights Watch issued quite a detailed report. I think they documented over like 1,000 takedown cases in over 60 countries. Of course, that's not enough to talk about, a proven systemic failure or anything, but this is something that I would hope that the Commission would also start looking into. This is not something that is like directly protective of freedom of expression and content being able to stay up on the platform, I haven't quite seen yet. And just very briefly beyond that, I think, again, we need a bit more transparency, because, say, the due diligence obligations on very large online platforms are obviously a key aspect of the DSA. And there, for me, it's not quite clear. I mean, they've seen the risk assessments and the mitigation measures. They've taken some step in response, but not having access to these dossiers is very hard to say what have they actually been missing or what have they not been missing. So we need more clarity and more information on that, I would say, before being able to really comment.
Yeah, thanks. I very much want to second everything that Chantal has just said, both regarding the need for more transparency around what exactly is being investigated, which is very hard to judge at the moment, and also certainly this over-removal of political content, particularly in the context of Palestinian advocacy, is a super, super important issue that absolutely deserves to be investigated more. And I think given at the moment that we have Thierry Breton and the Commission sort of pushing the platforms to take down more Hamas-related disinformation, take down more illegal content. They're being threatened with enforcement proceedings for not taking down content whenever it is flagged by law enforcement, which I think they're very much pushing in favor of more censorship of that kind of content and not less, which is very concerning. But I mean, relatedly to over-removal, I think the biggest issue that has really been missing so far from the Commission's enforcement strategy for me, I'm somewhat biased probably because I'm doing my PhD on it, but I do think it's very important. And I think the evidence for issues in this area is far, far stronger than the evidence for things that are being investigated, like impacts on child mental health, where the empirical evidence base is actually really not there. And that is algorithmic bias and discrimination in content moderation, which has been really well documented by both quantitative and qualitative scholarship in a range of disciplines. There are many, many accounts from social media users and creators, as well as independent academic research. And of course, also it fits with what we know just generally about how AI and kind of content analysis software functions in general. Anyone who works in this field will know that algorithmic bias is a very pervasive problem and one that is pretty intractable and pretty difficult to solve, but that there are mitigation measures and sort of things that can be done to at least reduce the problem. So I think it's really kind of quite surprising and disappointing that given what we know about these issues, that the Commission is not using its not only enforcement but also investigatory powers, so requests for information, for example, to see what the platforms are doing to ensure that their moderation systems are not systematically over-removing content from some groups more than others. Because this is very clearly within the scope of the DSA. The systemic risk assessment provisions refer very explicitly to non-discrimination as well as to freedom of speech. There are recitals of the DSA stating that content moderation should be objective, fair and diligent. And I think that all of the evidence that we see at the moment suggesting that content moderation policies are applied very, very differently in a very arbitrary fashion to people that are from the more like marginalized or stigmatized communities. So people like LGBT people, people of color, Arabic speakers, probably because of all of the sort of stigmatizing associations with terrorism and political extremism. It's been documented by organizations like Access Now brilliantly that if you're speaking Arabic on social media, you're much more likely to see your content being arbitrarily removed. So I really think that this is something that should be a priority for risk assessment going forward, also because it's not just related to one platform, but it's an industry-wide problem. So it would be really, really positive, I think, to see the Commission starting to send out kind of maybe like standardized requests for information for all of the platforms, all of the VLOPs, to see what they're all doing relating to these issues, and then we would have some basis to actually start getting a sense of what are the best practices, what can be done to mitigate it, what are platforms doing well, what are they doing badly. So that, I think, just because of the evidence base that exists and because it's such a glaring omission so far, I think, would probably be the one thing that I'd most like to see. But I think there's something else that, again, I think is meaning to come to later, so I won't go into too much detail now, but I think the other really big issue that has been overlooked so far is about sustainability and environmental impacts. These are, of course, not just big tech, but they're literally some of the biggest companies in the world. The environmental impacts and implications of their businesses are really astounding. And if we want to talk about human rights risks, about corporate due diligence and so on, I think this is really something that also needs to be very central in the conversation.
Thank you so much. Yes, and we will get to that point because I think it's worth really including that in the discussion. But maybe let me dig one level deeper into the content moderation question. You both mentioned over-removal as an issue and algorithmic bias. And I was wondering, to what extent there is already a conversation happening. You say, obviously, we need to know more about how platforms are using the tools that they're using and what the impact is, so we need more data about it. But is there already a conversation in academic circles and also in civil society about how these requirements that you mentioned are for objective, fair, and diligent content moderation, how they can be operationalized by VLOPs in order to then be compliant? Because obviously these are words that, you know, are hard to kind of put into practice and hard for a regulator to also operationalize them.
Yeah. Well, I mean, the first thing I would say is that objective content moderation, I think that's a fantasy. I mean, how could any sort of application of a system of rules about what is harmful speech or what is healthy behavior on a platform, the idea of any sort of inherently like values-based set of rules like that ever being applied objectively is just nonsense. So I think moving away from the idea of content moderation being objective, we need to start thinking about what kind of values it is reflecting and who is able to shape those values and participate in governance beyond just the commercial interests of platform companies. So I think, yes, there are conversations happening in this issue. It's starting to get more prominence in academia, although I think there's maybe been a lack of attention to it so far in legal academia. I think there's really, really great work going on in sociology, media studies. I'm thinking of people like Alex Murena, Carolina Ari, who are doing really, really groundbreaking work on this and kind of documenting these unequal impacts. So engaging with people like this, engaging also with civil society organizations that are working on this. So of course, Article 19, other organizations like Access Now do really great work. But it's very much not just the sort of the digital rights organizations that have so far been very central in this debate. So for example, there's a sex worker collective called Hacking Hustling that has done really brilliant, very robust academic research documenting how LGBT people and sex workers tend to be particularly subject to over-removal. So I think that engaging these organizations, not just by sort of the platforms voluntarily deciding to talk to the organizations once in a while and sort of picking and choosing who they're going to listen to, but having much more formal, institutionalized and transparent structures for best practices around, you know, the pursuit of fairness and the public interest in content moderation going forward, because I don't think there's some kind of objective standard of fairness that can just be achieved. I think it has to be an ongoing process of allowing the communities that are impacted by these issues to actually have more of a voice in how they're being dealt with.
Yeah, I agree with what Rachel said, and I would also add that I find sometimes, I mean, we have these like community standards, right? And they might differ across the platforms. I think TikTok's is much less detailed than, for example, Meta's. But if we take, for example, Meta's ones, they're very detailed and they give a bit of an illusion of how this is all a totally rules-based system that they follow. But then again, you see, you hear about things like, again, Arabic content being disproportionately removed based on which rule. So it feels like it's very much influenced by factors that were very much outside these community-based rules that are like so detailed and give this illusion of this being all like based on due process, etc. And I think, I mean, the question around content moderation specifically, I think it's a difficult question around, you know, can you quantify what means compliance with the DSA? Are there like benchmarks as to what does it mean having complied with the DSA? What does the outcome have to be? I think it's a complicated question. In the end, I would say it's very much risk-based as well. I mean, I wouldn't say, you know, content moderator per million users. I don't think that works because it needs to be, are we in a volatile context? Do we have more hate speech that we see proliferate in a certain language in a certain country? So I think that those are the factors that should probably be taken into account. And there, I think, again, platforms have to deliver first and show us what are their considerations, what have they done. Because we see there is over-removal. Again, there is evidence of the results. How exactly they got there and why is still not clear. And just one small thing to mention that I find is a bit of an oversight in the DSA as well, that it talks mainly about also European languages, when we have a lot of diaspora communities in the EU, or also that we can see content that is generated. I mean, I'm able to see the content that is generated outside the EU. And that is presumably also being moderated by the platforms and decides what users in the EU get to see. So I think there it's not quite clear what the Commission, whether they look into this, whether they take this into account when they assess compliance with the due diligence in this respect.
Thank you. Claire, if I may come to you, and now you work in the DMA unit, so the DSA is obviously not your central piece of work. But I wanted to give you the space to respond if you wish to, but also maybe adding the question, now we've heard 2 times that transparency is an issue, both when it comes to the question how the enforcement is actually done, or how the investigations are going, but also in terms of how do we know what the platforms are actually doing. And so I was wondering, why is it? What are the problems? Why is it that there is so little transparency and that the Commission as the lead enforcer can't share more of it, or maybe they can?
I don't know if I can really reply to that question because I've not been part of, let's say, this internal discussion arbitrating what is communicated or what is not.
I don't think it's
You hear me? Ah, yeah, sorry. So I'm not sure I can really, provide even in the internal insight on how this has been discussed. What I just as a reaction, because in order to prepare a bit for the panel, this is something I discussed with the DSA colleague, at least around your question about how do we assess somehow the obligation of means that is on, in fact, very large online platforms to ensure appropriate content moderation within the law. And this is true. There is no threshold, as you know, and this is not how the DSA has decided to approach let's say, this obligation of means. For me, coming from a data protection and privacy perspective, when I hear about that, I mean, this is very similar to security. That's why I'm speaking about an obligation of means. And so obviously there is not necessarily an obligation of result. But having worked a bit on the enforcement of data protection law, this is not impossible to assess. At some point, you need to put, and you can put a number of questions to a company in order to check and verify whether they have diligently put in place a framework that is adequate to meet their obligation under the law. And it's true, even without specific threshold in the legislation, a number of factors can be, let's say, investigated and inquired further in order to understand how a specific company and whether the resources or means made available are likely to somehow fulfill, let's say, what the law requires them to do. So it's true, translated operationally is a bit difficult, but I don't think this is something that cannot be made, if you want, or that cannot be contextualized and assessed in a case-by-case assessment. And this depends, of course, on the platforms and on the number of factors, like the platform's risk profile, the type of user behavior and content on the platform, to what extent automation is employed or not, and the amount of notices received and processed, for instance, by the platform. And it's true that the human resources devoted to this could be an indicator of a risk that the obligation of means is not, let's say, respected. That's why towards X there has been some, let's say, concerns that the drop of the resources in this area of this company could create potentially certain issues on content moderation. But that's one indicator among, of course, others. Bon, on the transparency of DSA proceedings, maybe it's just maybe a personal, let's say, take. You know, it's also, I understand, and there is an interest in civil society, of course, to know more about what the Commission is investigating and how, and I think there will be a point in time where this will, of course, become more, let's say, communicated. It's also early stages of early enforcement, you know, of this law. So to some extent, these things are also adjusting. What can be communicated, how far, you know. So I'd say that this is also something that will probably get more mature over time, you know, and addressed maybe more comprehensively and in a more structured way on how, of course, to keep at the same time the integrity of the proceedings, because it's also very important, and make sure that our action are not put at risk in what is communicated to the public. So voilà, this is the only thing
I think it's a really interesting question, because a similar question obviously is there in the context of the DMA, where the Commission has held, and probably many of you have seen that, the whole range of publicly streamed workshops with the gatekeepers. So we know the compliance proposals, we know what how they defended them, the gatekeepers, when they were in those workshops. But after that, nothing. So we don't know how the conversations have been going since, and whether there have been changes to those proposals, and so all of these details. So I think similar questions arise for both laws, even though in different contexts. Anyone else wants to jump in on this? No. If that's not the case, I'm sorry about that, but I've got to go back to TikTok, because a couple of people have mentioned TikTok, obviously, and I also know that they're here at the conference, so I think it might be interesting to delve in this a little deeper. It was mentioned in the context of Spain, where the Commission basically has forced the company to suspend the new service, and it was mentioned in the context of France, where in New Caledonia, in the context of unrest, France has not used the DSA, but a national decree to ban the platform, basically. And in a publicly televised speech, as far as I know, President of the Commission von der Leyen has, and other EU candidates, by the way, as well, have publicly signaled support for having at least a European discussion on banning TikTok on the continent, a little bit modeled after the discussion that we've seen in the US. So I was wondering, to all of you here basically on the panel, what would that mean for the right to freedom of expression? Why does everybody target TikTok? And how can that be squared with the regulatory toolbox that the DSA provides? Who wants to go first?
I'll try to keep it brief. But yeah, so first, I mean, in terms of what von der Leyen has said, I think that this needs to be very much understood in its context as part of an election campaign. And, a campaign in which, more broadly, von der Leyen and the European People's Party group are very much trying to profile themselves and to distinguish themselves, in particular, from the far right, where, otherwise on things like migration policy, there's not much to choose between them. They're really trying to distinguish themselves by being very kind of tough on security, national security, geopolitical issues, and so on. And of course, that also kind of answers your question, why TikTok? Of course, because there's this whole narrative of China as our great geopolitical rival and security threat. In terms of whether we would take it seriously as something that could happen, it is possible within the DSA to disable access to a platform entirely. This would have to go through a judicial procedure, so it couldn't just be done by a commission decision from one day to the next, but it could happen. But importantly, it's only available where there are serious ongoing infringements of the DSA, and all other possible measures to address those infringements have been exhausted. So there would be a lot of other steps that would have to be taken first. So not only investigations, but regulatory measures, development of an action plan by the company in question, and so on. So it is not something that I think we would be seeing happening anytime soon. I think the much more immediate concern is things like what has just happened in France or in France's overseas territory, New Caledonia. But importantly, it was actually discussed during riots in France that were protesting police racism and violence last year. There were some very senior government ministers that raised the possibility that they would ban TikTok because they thought it was that content being spread on TikTok was encouraging these riots. And I think that's what we're much more likely to see in the short term, this sort of more targeted repression that is targeting communities that are already stigmatized and are very easy to construct, again, as some kind of security threat. In terms of the implications for freedom of expression, I think it's very hard to see how this could really be justified as a proportionate response or the least intrusive measure possible to address concerns around things like national security and child safety. As I said before, I think the impacts of these kind of platforms on child safety are not particularly well evidenced. It's very, very much disputed. The national security concerns, again, I think that singling out TikTok in comparison to other platforms is sort of questionable here. And I think, that the idea of this as a sort of a proportionate targeted measure is quite hard to justify.
Yeah, so maybe very, very briefly for those who haven't followed the development so much in the US, so banning TikTok has sort of been a sexy topic there and a political topic for a while, and now Biden has actually signed a law that says within 1 year, TikTok owners, which is controlled by China, ByteDance needs to sell TikTok basically to another, or like the US segment, I should say, of TikTok to someone else. Otherwise, they will be banned. And I mean, what we observed there, for example, they made this national security argument. But to take a measure, I mean, in the US, TikTok is used by, I think, 170 million users. They will obviously also have like, they have millions and millions in the EU. And we need to remember as well that the DSA is relevant, but also international human rights standards play a role here. And to take such an extreme measure as banning a platform that, whatever you think of them, but you know, it's used for sharing political expression, artistic expression, comedy, to connect with people. To take such an extreme measure, you really need to be providing quite substantive and detailed evidence as to what is the national security threat, for example, or what is the threat to public order, and why is this, again, a necessary and proportionate measure. And it's quite clear under international standards that banning a platform is very rarely justified. And as Rachel mentioned as well, whether in the US or obviously focusing on the EU, you would have to show also like how, again, is TikTok non-compliant with the DSA in a way that Meta or X or YouTube would be compliant with the DSA. Just saying, like, you know, there's China somewhere in the back will certainly not be sufficient to justify that. So I very much hope that this is not where things are going. Yet I do find, again, just sort of off-the-cuff political comments in that direction. They just don't create, I do feel that they create a bit of a climate where these measures are more and more invisible, and that in and of itself I think is very problematic, and that's why I think it's important to push back on such comment, even if they're not like official enforcement actions yet.
Thank you. Before we come finally to the question of the technology's impact on the climate and the environment, let me just jump back to the DMA one last time. So we've already talked about the workshop that the Commission has held and the compliance reports. And Rick, you said the compliance reports aren't great. So I was wondering, beyond the example of the App Store with Apple that you mentioned, can you give us more insights into where you think the biggest kind of the biggest holes are, where the weakest spots are, what has annoyed you most? Where do you think the Commission should focus on?
Sure, yeah. I think in answering that question, it's useful to give some background to give people a little bit of an idea about the types of things that big tech companies do to keep competition out of the market, because that's basically what we're talking about here. And there's one very concrete example from the past that's nice to mention because it's very clear. It's been solved now because the Commission fined Google for this behavior for a couple of billion, I think, which is still being appealed, if I believe. So up to quite recently, Google made smartphone manufacturers who wanted to load Android on those smartphones. They made them sign an agreement saying that if they ever sold one smartphone with an alternative operating system on it that was Android-based, but not Google's Android, that they would lose all their clientele with Google, which made it impossible for any other Android maker to work together with smartphone manufacturers because, you know, Google had 99% of the market and they could not afford to lose that. So it was impossible for companies that made an alternative to Google's Android to get an entry point into the market. This is a very clear anti-competitive behavior, and the European Commission has said, you know, this is illegal, and Google has been fined. And now for devices that are made and sold in the EU, Google is not anymore allowed to do this. Although I think legally they are still allowed to do it elsewhere because there hasn't been similar rulings in other countries. And so this is just one example, but this happens all over the place in almost every area where there's competition with all big tech companies. So something that we are still struggling with Google is Google Play services. So when you look at Android, for example, the core is open source, and that's what we built from too, but based on top of that core, Google has made Google Play services, which is approximately 50 APIs and services that are proprietary. And there are some efforts to copy those services and APIs, because many of those services and APIs are needed by applications to run on Android. So the problem is, if you make an Android variant today without that layer of Google Play services, many apps stop working. And there's been some work to correct this, but Google keeps adding things to this package to undo that work. And so a famous service or API in this package that makes it very difficult for us to make sure that all applications work on our Android-based operating system is used to be called Safety Net, and it's now being re-termed by Google to be the Play Integrity API. But basically how they market this is as an extra security measure for companies that want extra security in their application, and many banks want this, for example. And then when a user installs the application from that bank, for example, a check is an extra security check, says Google, is issued. But the consequence, what Google really does in that check is it checks whether the operating system that's running on the phone is Google's Android and not some other Android. And if it's any other Android, the Play Integrity API says this is not a secure operating system, so this application cannot run. And this is really problematic for us because it means that we've had to fight really long to get banking apps to work on our operating system, which for people in everyday use nowadays is vital. Like, we all do everything with our mobile phones. So, and this sort of stuff happens everywhere, all the time. And so I think what's really important about the DMA is that we're finally moving towards a policy framework where we're able to address these things more quickly, and in some cases even proactively. Because if you do it just with fines, as has happened in the past, you're always too late. And then, sure, Google gets fined $2 billion, but then they've had a monopoly over the market for 10 years, and that has grossed them much more than that $2 billion. And then they just, they create something new in another technical area that gives them a monopoly. So it's, this is a good thing about the DMA, that we're able to act more proactively. But there are many holes, that was your question still. Google Play Services is one big hole. This really needs to be opened up. And we think that any application should be able to run on any Android variant, because it's an open source operating system and it should not be allowed to be made proprietary. Another big gap is app distribution, which is a little bit different from app stores. So there's a lot of talk about app stores, but what many people don't realize is that Google actually owns the data warehouse where all these applications are hosted in the cloud, which is approximately 5 million applications. And there are alternatives by Amazon, for example, and Huawei has tried to establish a new one, and there are some open source repositories, but all these don't even come close to the number of applications that Google has. And currently a lot of app stores pull these applications from Google's API, but there's no legal framework for this. And if Google decides to shut down those APIs tomorrow, like Twitter has done, for example, in the past when Musk took over, it could represent a real problem for people in terms of getting the applications that they want. So I think a lot of the monopolies that we see currently in big tech are less and less about the actual technologies, but are more and more about the data that are monopolized. And I think that's quite an important concept to grasp. It's also true, for example, for maps. Like, making a maps application is not hard today. We are making one now, for example, in our operating system. You can do that for a relatively low amount, but your big problem is getting the data that people expect these days in a map application, like company data, reviews about restaurants, and all those are quite often monopolized by big tech companies. And sometimes there's competition, but very often there's not. And so the big gaps, Jan, are the areas where there are data monopolies or proprietary software monopolies.
Thank you so much. Claire, do you want to respond to this? I mean, like any moderator, I see I'm running out of time slowly because I want to give some space for Q&A afterwards. But if you do, then please go ahead.
Yeah, I mean, what he said, it made a lot of sense. Of course, to us, these are issues we are, of course, actively looking at. I mean, the DMA is really built also on the idea that the data accumulation gives a huge competitive advantage gatekeepers, and that's why a number of obligations in the DMA precisely addresses the obligation to share more data with app developers and all other business users. So it's a number of these, let's say, obligations actually also address specifically not only the open or closed or proprietary environment, but really the data that fuel, in a way, this competitive advantage that gatekeepers are having. So well, we are working on that, and we obviously hope to open up more all this with the DMA.
Thank you. Okay, before the Q&A, and then there's going to be 15 minutes at least for the Q&A, I still want to ask the question about how to address the environmental and climate impact of all that technology that we use today. I remember there have been attempts in the legislative phase for the DSA at least to add that impact to the list of the risks that very large online platforms pose, those who are voted down by a majority of lawmakers. So the question is the framework that we have today, including the right to repair and similar things, is that enough? And if not, what else would we need in order to address those things?
So certainly it's not enough. At the same time, I think that we're in an urgent crisis situation where absolutely anything that we could be doing to cut emissions, we should be doing it. And I think that actually the DSA does present some very promising sort of levers that could be used to do this. I've written a policy brief about this that was published by the Hertie Centre for Digital Governance. So if anyone's interested in this topic, I would encourage you to check that out, where there's a bit more of a developed legal analysis. But I think the important point is that the fact that climate and sustainability are not explicitly mentioned in the risk assessment provisions of the DSA is unfortunate, but not really a barrier, because it mentions human rights, fundamental rights, and of course, as we know from a series of legal cases from the Supreme Courts of multiple EU countries, recently also from the European Court of Human Rights, climate change is above all a human and fundamental rights issue. The DSA also explicitly mentions public health and public security as important systemic risks. And given that I think 60 to 80,000 people died from heat waves that were affected by climate change in Europe in 2022, I think it's quite hard to argue that it's not a public health or public security risk. And we know, of course, that the platform companies that are regulated by the DMA and the DSA, so the biggest, the most widely used, and the most important intermediaries in our digital economy, are really major contributors to these risks. So just to kind of give you a couple of stats that put this in perspective, data centers in the EU by 2030 are going to be consuming more electricity than Belgium, than the entire country that we're in right now. There was reporting in the Financial Times recently on how fossil fuel executives are getting really excited about all the current AI developments that we're seeing, because they're expecting that this is going to be a big boost for the natural gas industry. But also, it's not just about the direct impacts of the digital technologies themselves. So these platforms are also very, very significant intermediaries for a lot of commercial and economic activity. So for example, Amazon, Shein are both designated as VLOPs, and they're intermediating billions of dollars worth of consumer spending, often, especially in the case of Shein, but also Amazon, in ways that are explicitly encouraging extremely unsustainable consumption behavior. The use of the production, not just the use of digital hardware is a massive contributor to climate impacts. And let's remember that it's not just the sort of consumer-facing, like social media online platforms that are regulated by the DSA, but also the app stores, which have a huge influence on kind of hardware development and kind of consumer behavior. So I think that these are very, very much within the scope of Article 34 as risks that platforms should be addressing under the DSA. And I think there is a lot of scope to push, not just for them to be kind of actively taking steps to mitigate these impacts, where, again, I would not in any way suggest that this is a sufficient solution, but there is so much research out there on ways to mitigate and to reduce both the energy, but also the consumption of water and other resources of digital technologies. There is so much kind of low-hanging fruit that could be being implemented. We could also see, for example, the reporting obligations and the request for information being used to make a lot more information available about the impacts that these kind of businesses are having. So I think that actually the DSA really offers a lot of potential in this space that is not really being leveraged at the moment. And this is also something that I would like to see playing a much more prominent role in both the Commission's enforcement strategy and also the wider policy debates in this area. And especially because of that, I really want to thank EDRi for bringing it into this panel and bringing it into the conversation more.
So you're saying that, in theory, the Commission could already use the DSA today and go to platforms and say, look, if you want to fulfill your risk mitigation obligations, you've got to reduce your negative impact on the climate and the environment.
Yeah, exactly. I think that that is just as much within the scope of their sort of risks associated with the design and use of their systems as, for example, impacts on mental health or impacts on political polarization and disinformation. I mean, again, thinking about evidence-based regulation, the evidence that these platforms are contributing very, very significantly to increasing energy use, carbon emissions, water use is far more robust and far stronger than the evidence that they're contributing to political polarization and civic discourse, for example.
Awesome. Maybe we can pass it on to your DSA colleagues. Sorry, I got to say it.
I will disappoint you because I mean, I think this is a very, very important question, but indeed I don't, for now, the DSA may not be the ideal instrument to address this, or it's not, let's say, the designated and obvious piece of legislation. I see how you want to, under the risk assessment obligation, inject the environmental impact of how this is running, but I think that there are plenty of things that could be discussed, which are also dependent on our, addiction to videos, which are much more, content, which are also much more demanding in terms of power, and energy consumption. So I think this requires probably a dedicated impact assessment and legislative discussion. I don't, for now, for what I see, and I'm speaking only on my own and not on behalf of the Commission, I don't personally really believe the DSA would be an ideal instrument for this, but although it could have some avenues, but...
If I could come back, I mean, there is no ideal instrument. I mean, we've seen that the Corporate Sustainability Due Diligence Directive, for example, which was already very far from ideal, has been significantly watered down at the last moment. The AI Act includes very little on climate and sustainability. Of course, corporate risk assessment is not an ideal solution to the climate crisis, but at least it offers something that could be done. And again, I would really push back about the idea that legislation which very, very explicitly mentions fundamental rights due diligence, that the corporations should be taking steps to assess and mitigate fundamental rights risks, risk to public health and security, that doesn't somehow obviously relate to climate or to sustainability. All of our fundamental rights, as well as our health, our well-being and security, are so centrally affected by the climate crisis. I think it's very difficult to argue that it's not within scope.
Yeah, so I should say this is not really my area of expertise, but I thought it would be nice to add something to this discussion. I'm not sure though about the regulatory implications, but in terms of climate and sustainability, we very often think when we talk about technology, about data centers and energy use. But what's actually quite interesting to read about and not so nice for this topical area is that hardware is an incredibly complicated topic in this area, particularly because the production chains are incredibly long and very difficult to gain insight into. So any smartphone here in the audience very likely has gone through hundreds of different companies that have contributed to it in some way. And like if you see the web of organizations that contribute to one device, it's huge. And it's interesting to take that into account in these discussions, I think. And it's also really nice to read about companies that are doing actually a lot of hard work in this space to make things better. So a nice company to mention is Fairphone in Holland, which some of you may know. And it's really interesting to see, to read their annual reports. Often those can be quite boring, but theirs are actually quite nice. And if you read multiple year upon year, you really see the progress that they make in making these production chains transparent, and then trying to work with all the partners to improve both the human conditions under which laborers work, but also the environmental conditions in which the products are made. And again, I have no idea how this should be regulated, but I just thought it would be interesting to add that complexity around this topic. Also, the fact that those production chains are very often in countries where there's much less attention for this topic.
Thank you. Thank you so much for your patience, everybody. 10 minutes for Q&A. Are there any questions you'd like to ask? I think there's a microphone going on.
Yeah.
Thank you so much.
Thank you so much for the interesting discussion. I have more of a higher level enforcement question. So there's so many authorities at national level involved in the DSA and the DMA, but we also have the AI Act, we have the Data Act, and so on. So what are the ideas internally and externally to like bring more order into the chaos? Is it a dedicated enforcement commissioner? Is it a task force in the commission? So what are your ideas? What are the pros and cons? Thank you.
Should we collect 3 questions maybe and then do an round of answers? Yes. There's one of them behind.
Thank you. Andrew Adams, Major University. I want to pick up on Rick's comment about the hardware. One of the things that's been clear in the market is that these things are usable for a lot longer than the businesses that sell them to us want them to be. Is there scope within the existing regulations, either the DMA or the DSA or some other regulation, for enforcing the fact that this phone, it's 5 years old, I could put the latest version of Android on this. There is no reason why I couldn't, except that the telecoms provider and the hardware provider don't want to let me. Is there something we could do about that? Because I think that would be a huge win for the environment and a huge win for the pockets of consumers.
Thanks. I think there was another one at the very back.
Yes, thank you. Yeah, what strikes me with the enforcement on the content moderation is that we are effectively accepting private policing. Is there a way how we could bring that back into the public domain?
Thank you. Who would like to go first?
I can, I suppose. So maybe probably the most relevant for my work is the last question. Yeah, I think there are a lot of issues with private policing of content, but I mean, if we want to have large infrastructures where people are posting sort of billions of posts and comments every day, someone has to be policing them, and for both practical and political reasons, it probably shouldn't be the state that is reading and controlling everything that we say online. So I think some level of private involvement is somewhat inevitable. Does that have to be done by kind of enormous multinational corporations whose inner workings are very shadowy? In an ideal world, no, but unless we're talking about very, very radical structural reform of the entire social media industry, I think kind of in the short term, in the world that we currently live in, again, a high degree of private control of these communications is inevitable. And, you know, while I don't want to say that we shouldn't be arguing for radical structural reform, I think that we also need to be talking about how the kind of private policing that we're seeing at the moment can be done in a more accountable way, in a way that is more egalitarian, more inclusive of different perspectives and values. So I think that sort of the idea of bringing it back into the public domain, I think, is also very, very problematic, given the very, very high degree of politicization of online speech regulation.
Why is that such a big step to take that power of the content moderation away from the big tech companies? Because in many sectors, there's many things like, for example, audits that are on purpose taken away from the companies. You know, companies shouldn't audit themselves in many areas. And that's done by independent parties, sometimes non-profit, sometimes for-profit, sometimes public. Why couldn't that be done for this topic also? Why is that such a big step?
So you would be saying to have sort of the companies run as they currently are, but to have content moderation be basically outsourced to other companies?
Well, I think, unless I misunderstood the question, but I think if you're talking about taking that more into the community, I would see that being done by the people who are not organizing it, but having it done by other people, like different representatives of the community, or like in some way, but at least something independent with the citizens' interest at heart and not the private interest of the company.
Mm-hmm. So this is an idea that is very much like discussed in the literature. There are like people doing really great scholarship on it. There's a really good article by Daphne Keller about sort of both some of the she's a very big advocate for this kind of approach, but has written this article where she also goes into a lot of the challenges and the hurdles that it might face. So among them, I mean, content moderation is not just about the sort of the last step of like, you know, you have the platform kind of doing its thing, and then, you know, after that you sort of come in, review all of the content and decide what you're going to take down or not. It's not something that can be very easily separated from the rest of the sort of day-to-day operation and functioning of the platform. So I think it is a lot harder to envisage outsourcing it than something like auditing. To the extent that that could be done, which, you know, I'm not saying that it's impossible, it would raise a lot of questions around the privacy of the data that is involved. If you think about the kinds of content that people are posting on social media, not to mention, you know, their names, their identities, all their personal relationships, the idea of having third parties that would then have access to all of that information, and then maybe, you know, a more diverse ecosystem of smaller, you know, independent third parties. On many ways, that's very appealing, but it would be very, very hard to oversee that from a privacy and a security perspective and make sure that all of those third parties are trustworthy. And then finally, the idea that it's sort of popped back to like the people and sort of non-commercial interests that have the public interest at heart. I mean, great, but at the moment we live in a capitalist society, and what's the business model for that? Where are all of the resources of which that is very, very demanding going to come from if it's not from some kind of commercial business? And again, I'm not advocating that it should be done purely commercially, but if we want it to be done by independent, non-commercial third parties, where are their resources going to come from? Is it going to come from the public sector? Is it going to come from the private sector? Again, then like all of the same issues come back in about conflicts of interest, politicization. So I also would be really, really interested to see more exploration of this as a solution, but I do think that it raises a lot of complexities and a lot of political problems.
So yeah, maybe also I think this is one of the things that I feel is missing also a bit in the DSA, these like bold structural reforms that would look at, I mean, something we advocated for a lot is unbundling of like the hosting and the recommender systems, and also content moderation, like, you know, why not? It should be investigated. Obviously, there's also like, I think on Mastodon where it's more like decentralized content moderation. So there are alternative models as well that should absolutely be looked at. And one distinction that we always make as well, we sort of accept that the platforms may have rules that are can be more restrictive than what the state is allowed to restrict, but that's also where we make the distinction when you have like online regulation where the state is essentially asking the platforms to police speech. That is actually more problematic because states' human rights responsibilities are at a higher level than the platforms. But again, having said that, we would welcome any sort of more braver, bolder structural reforms because I also think like the status quo is sort of accepted, and we're trying to sort of mitigate some of the risks without really looking at broader changes that can really open up the platforms and make them more publicly accountable for sure.
Okay, we have 2 more minutes. Who can answer the other 2 questions?
I can say a brief word about your question and how, let's say, the cooperation is going, on how things are going between the national, you know, level and the European level. I mean, I think the proposed enforcement system tries to really leverage the best of the centralized enforcement and the best of the national enforcement. So the idea is that, let's say, to best leverage the most appropriate resources at the national level, whether national competition authorities or DSCs in the context of the DSA, and to bring at the Commission level what could be more efficiently addressed in a centralized way, if you want. And then all this, of course, requires some cooperation, adjustment, and dialogue between regulators. And we have a number of mechanisms for that. We have the high-level group under the DMA that is meeting regularly, and where the exchange of information and discussing, you know, market trends or sometimes even, you know, interpretation issues, etc., can be brought, you know. So this, of course, but this is the story of the Union, let's say, in a way.
Thank you. And last but not least, what do we need? Why can we use the DMA to use our phones longer?
Yes, I have no answer to this question because I'm not the European Commission, but I will add to it that it's a fantastic question because maybe we can all leave with this fact today. More than 70% of the environmental impact of smartphones lies in their production. So extending their use is actually the biggest thing we can do for the environment, more than anything else. So great question. I have no answer. There are some good things happening, both in the policy area with the right to repair, but also I think we see now the larger companies promising 7-year support times, and that used to be between 1 and 2 years. So it's getting better, and I think we're moving slowly towards a different model. But yes, companies have been allowed for much too long to do this in a really bad way. I agree. But as I said before, there are companies like Fairphone that really do this differently. So that's also a way in which we can contribute to change by going for those manufacturers.
A big thank you to the panel for all this contribution, and thanks for your questions and your patience.
Thank you.